ᓄnaᖃᖅ ᓄnaᖃᖅ ᓄvialanaripuk maligalirnirmut katuki gatigit nunavumi tungasu tisinigit ukaktinik amalu kinakulimarnik nakitu enactunik kanatami upaku tisimayut ᓄnaᖃᖅᓅᓄθ ulumi. Bienvenue à tous. Welcome to all. My name is ᓚnaᖃᖅqədαᓅ. Such a pleasure for me, on behalf of the Law Society of Nunavut and its executive members, to have this opportunity today to welcome you all from every part of the country to this first-time webinar series in partnership with LexisNexis Canada. Pilirakitiginik, let us continue to work together for a common cause. Continuons de travailler ensemble dans un but commun. Today's event is even more on point, given Friday's Supreme Court decision that was rendered with respect to Bill C-92 in relation to the Act respecting First Nations, Inuit and Metis children, youth, and families. With many thanks to our panelists and CLE team members for the extra hours they've put in over the past weekend. Please allow me a moment to introduce our panelists, Professor John Borrows et ma consoeur, Maître Caroline Brillat. John Borrows is a professor of law at the University of Victoria and the Loveland Chair in Indigenous Law at the University of Toronto Law School. He is the 2017 Killam Prize winner in Social Science and the 2019 Molson Prize winner from the Canadian Council for the Arts, the 2020 Governor General's Innovation Award, and the 2021 Canadian Bar Association President Award winner. He was appointed as an officer of the Order of Canada in 2020. Professor Borrows is a member of the Chippewa of the Nawash First Nation in Ontario. He's also an acclaimed author, and I invite you to have a look at his detailed bio on the registration page with an impressive list of publications. I bring to your attention, in particular, the 6th edition of Indigenous Legal Issues, which is available. Maître Caroline Brillat is a partner in the litigation group at Langlois Lawyers Office in Montreal. Caroline advises Indigenous governments, organizations, businesses, and individuals, particularly in matters of Aboriginal and treaty rights, Aboriginal title, hunting, fishing and trapping rights, funding of public services and access to these by Indigenous communities and individuals, review and implementation of governance processes, as well as mining and other natural resource development. Moreover, Caroline advises and supports organizations and institutions in matters of sexual violence and discrimination, particularly in the context of administrative investigation. She is certified by the Barreau of Quebec as a lawyer who conducts workplace psychological harassment investigations. Since her beginning, Caroline has worked in Aboriginal and constitutional law, and she's passionate about the history and legal and social concerns of Indigenous peoples in Canada. Our moderator, such a pleasure to introduce you to Nastanya Mullen. Thank you, Nastanya Nakumik, for accepting this invitation to be our moderator. Nastanya is a proud Inuk father originally from Resolute Bay, where his family was relocated from northern Quebec for Canadian sovereignty. Nastanya is also a Nunavut Law Program graduate and a member of both the Nunavut and Manitoba bars. He's the CEO of the Manitoba Inuit Association since the fall of 2022. Nastanya was part of the first cohort of the Inuit Learning Development Project, where Inuit work for the federal government, Nunavut Tungavik, and the government of Nunavut. He later held the position as sustainability coordinator, where he traveled to every Nunavut community to better understand their short, medium, and long-term infrastructure needs. Afterward, Nastanya held the title as project manager of the Devolution Secretariat for the Nunavut government, worked as a summer at the federal prosecutions, as a law student, and a summer as director of policy at community government services. Thank you to the LexisNexis team and to Rachel Kohut, who's an invaluable member of the Law Society's team. We had planted a seed about 2 years ago, and here we are today. I wanted to just share 2 little housekeeping items. If you have any questions, please put them in the chat. And we will also do our best to answer all of your questions. However, my email will be posted with the recording once it's available. So if there's any questions we were able to answer, please feel free to email me, and we will do our best to respond in a timely manner. Before turning it over to Nastania and our panelists, I wanted to share a warm welcome, Tungasugit, bienvenue, to Chief Ghislain Picard of the Assembly of First Nation Quebec Labrador and Chief of Staff François Véro Paul. What an honor to welcome you today. Thank you, ᓄnaᖃᖅબાᓅᓐ. Merci à tous. Over to you, Nastania.
Thank you so much, Nalini, for that thorough and very heartwarming introduction. So without further ado, we're going to jump right into it because we do have only an hour for this. So I'm going to start off the discussion with a question that will be for John to get right into it. So John, why is it important for Indigenous communities to take back control of child and family services? And what jurisdictional difficulties arise when attempts are made to try to do so?
Yeah, thanks for the question. It's great to be here with everyone today. You know, this idea of Indigenous communities taking back control is rooted in the necessity of our own people having responsibility for our own affairs as Indigenous peoples. That is, the persuasiveness in applying law is often much greater the closer it is to the people. And of course, that requires checks and balances sometimes to ensure that those that are close aren't taking advantage of that position of power that they find themselves in. But nevertheless, looking for ways that Indigenous peoples can themselves administer their own law, take control of family and child services is just key for the effectiveness of the law. Of course, there's other reasons too, and some of these are found in the preamble to the act that is respecting First Nations, Inuit and Metis children, youth, and families. Things like eliminating forms of racial discrimination. As you know, Indigenous peoples have long been poorly treated, tragically treated at the hands of the child welfare system. And our families have suffered through residential schools, intergenerational trauma, many policies and practices of moving us around and not letting us be as families. Particularly, there's been a disruption of Indigenous women and girls in relationship to child and family services, which has really impacted in a way around gender that's just, again, tragic. And then, of course, it's important to note that the idea of reuniting Indigenous children with their families and keeping those children with their families and preventing those children from being removed from their families is why it's so important that this occurred. That is, Indigenous peoples take back control of child and family services. The jurisdictional difficulties in doing that is often our own authorities as Indigenous peoples are not recognized. And then the federal government has a view that historically was trying to assimilate us. And so a lot of the legislation in that larger time depth has created difficulties in us being stepping to the table. And then, you know, in a place where the provinces and territories are now more active, it's sometimes the situation that our voices get lost as Indigenous people. So there are many reasons for us wanting to have responsibility in relationship to our own families here. And so maybe that's a start.
A very good point. So following forward from this, what are tensions that arise when Indigenous communities try to integrate their legal traditions, systems, and sources of law within the colonial legal framework?
Yeah, well, there's kind of two tensions. One is Indigenous peoples are seeking to be different than other Canadians in that we have our own nations and relationships that we need to ensure are effective. And so we're seeking to be different from other Canadians, but we also need to be recognizing that we are different from one another as well. And so some of the challenges arise because as Indigenous peoples, we have different views from one another as to how we would exercise these powers. And so part of what we need to find is ways that we can disagree with one another in agreeable fashions. And how do we do that? Well, we do that by identifying our own principles and processes for talking with one another that allows for us to disagree and yet keep finding ways to keep talking with one another despite our disagreements. This is to say that Indigenous peoples long have had laws. It's a human function to have laws. We have standards, principles, criteria, authority, measures, signposts, guideposts, indicia, again, for regulating affairs and resolving our disputes. And part of the difficulty in working in this field is to ensure we've got a good set of patterns in place through harmonization, coordination, looking to reconcile the different views that are there within our own communities is probably one of the biggest challenges. But we're up for that, and communities are doing that. And then the next challenge is, given that we are searching for that harmonization, how do we harmonize that with territorial governments or provincial governments and other settings and federal government? And that work has to include Indigenous law. It can't just be law that's imported from the federal, territorial, or provincial jurisdictions. And that's a challenge for many Western governments to see Indigenous law as a part of the way they might do their work. And so I'm saying two things here. One challenge is within finding that harmonization. And then the second challenge is finding that harmonization with the broader governments, given that they don't often see what our principles are as law.
Very interesting. So Carolyn, I'm going to come over and ask you a question. So incredible timing for the decision to be released on Friday. Let's just acknowledge that for a second. Given many people in the audience might not have a chance to have read it yet, and many in attendance do not have a legal background, could you please provide an overview of the Supreme Court decision on Bill C-92?
Absolutely. So if we take a step back as to how this case went to the Supreme Court in the first place, it's important to keep in mind that it's a reference. So a reference is basically when a level of government, in this case, the government of the province of Quebec, asks the court to provide an opinion on a question of law. So it's not a case that stems from an application of the legislation. It's not a case that stems from actual concrete facts. So the government of Quebec asked the Court of Appeal of Quebec originally to provide them with an opinion in a reference as to whether the law was constitutionally valid. In other words, whether the federal government had jurisdiction to enact this law, knowing that in cases where non-Indigenous persons are concerned, child family services fall under provincial jurisdiction. So there was a jurisdictional battle between the federal and the provincial government. And what happened in at the Quebec Court of Appeal was that the Quebec Court of Appeal, in addition to acknowledging that the federal government had jurisdiction to legislate and enact a law that essentially gave or acknowledged the jurisdiction of Indigenous communities, Indigenous groups, to set up their own child and family services laws and systems. They went a little further, and they actually, the Quebec Court of Appeal actually acknowledged the existence of an inherent right of Indigenous peoples in Canada to self-determination in child and family services. And they further went so far as to characterize this inherent right as a generic right. So a generic right being a right that is common in its characteristics and in its relationship to all Indigenous groups in Canada, as opposed to the classic approach of courts to Aboriginal rights, which stems from the Vanderpeet case back in 1996, which requires Indigenous group to prove before a court their rights practice by practice. For example, the right to fish at this time of the year on such portion of the river, this species with this or that tool or in this or that manner for a specific purpose. So it's a very Vanderpeet approach is very specific. It's often criticized because it presents Aboriginal rights in a way that's like little snippets or little pictures, and it becomes very almost like a caricature. It reduces Aboriginal rights to little caricatures or little images, like almost like folklore. Whereas the generic right is really about, this approach is really about acknowledging the rights that Indigenous peoples have because there are peoples. So obviously, the Quebec government was not very pleased with the Court of Appeal decision, so they appealed to the Supreme Court of Canada. So their appeal was essentially to ask the Supreme Court to determine that the federal government did not have jurisdiction. The federal government, the Attorney General of Canada, also appealed to the Supreme Court of Canada to obtain a declaration that the only two provisions that were struck down by the Court of Appeal were in fact constitutional. Those two provisions incorporate by reference the laws that First Nations and Indigenous groups have made or will make under the law or under the Federal Act. That is, in other words, those are the two provisions that will guarantee that the laws enacted by Indigenous groups in Canada in respect of child and family services will have precedence over other existing legislation. So at the Supreme Court, what was decided last Friday, first, the Supreme Court of Canada confirmed that the federal government had jurisdiction to enact the law. So it confirmed the validity of the Federal Act. And it further granted the appeal of the Attorney General of Canada. So those two provisions that guarantee the precedence of Indigenous legislation for child family services are also valid. So it's a total scheme that was validated by the court. So this is interesting because it essentially sends a message that the communities, the First Nations, the groups that will enact their laws in child and family services will have some legal certainty. They won't be caught between a federal and provincial battle of jurisdiction. So it won't be like the Jordan scenario all over again. They will have certainty, and they won't have to fight their way to the court to protect the integrity of their system, or to make sure that, for example, the orders that are rendered under their, or the decisions that are rendered under their youth protection legislation will be recognized by courts and susceptible to be enforced. So that's a huge win. Unfortunately, the Court of Canada, and unfortunately but predictably, the Court of Canada didn't go so far as the Quebec Court of Appeal. They did not confirm that there exists an inherent right of Indigenous people of Canada to self-determination in terms of child and family services. They did not step into whether it's a generic right or not. That being said, they gave us very useful hints that the Vanderpeet approach is a little bit outdated, and that we're moving forward to an approach to Aboriginal rights that speaks more to the human rights aspect of them. So it will snippets, little caricatures of Aboriginal rights. For example, the distinguished previous case law, namely the case of ᓁ in which the Supreme Court of Canada said that there's no such thing as or they did not in that case recognize an Aboriginal right to self-determination. The court actually said that they distinguished the case by saying that the Supreme Court has never heard before or never been seized with a case dealing on self-determination, dealing with matters so fundamentally attached to Indigenous culture and identity as child family services. So basically, they're just saying, we're not saying no, we're distinguishing ᓁ and the precedent that closed that approach, but we're just waiting for the right facts to come to the court. So that's, it's not like the breakthrough and historical decision that many were, and including myself, were keeping their fingers crossed for, but there are very useful hints, and those hints are even more powerful, in my own humble opinion, because we're dealing with a unanimous decision. So it's all of the justices of the court coming together, and in one voice.
Very well said. And you started touching up on this a little bit. What will the impact of the recent decision from the Supreme Court of Canada regarding Bill C-92 on Section 35(1) Test B?
So at the moment, unfortunately, there's no shift. There's no shift in the test. So we're still stuck with the Van der Peet approach, but there are like chinks in the armor. Like we've started to gnaw at it. It can be useful for the participants to know that in the fall, a case was decided before the Superior Court of Quebec, in which Justice Sophie Bourque set aside stare decisis regarding the Van der Peet test, stating she basically came, that's fancy legalese for saying that a test or a precedent can be set aside because it's not up to date with the current state of the law and Canadian society. So resting on the grounds that now we have to take into account that Canada has ratified UNDRIP, so the United Nations Declaration on the Rights of Indigenous Peoples, and has embraced a path or a journey towards reconciliation. The very specific caricatural approach in Van der Peet is not capable of capturing the nature of Aboriginal rights as human rights. So she set aside the Van der Peet approach and proposed a new test which puts the Indigenous legal frameworks front and center. So it's not a matter of whether, it's no longer a matter of whether the picture or caption of a practice before contact as continued today. The central question will become, did the Indigenous legal system that pre-existed the colonial legal system protect that right? But this is not, this decision is being appealed, so we have no guarantee that this approach or this new test in the decision of the Queen or the King against White and Montour will be confirmed. But this is another sign that we're at a crossroad. There's a shift, or there's a change coming on. And the decision that Supreme Court rendered last Friday, I think, gives us the same indications.
Very good point. So I'm going to answer a question to make it to ensure that the attendees are also getting their questions answered. John, so in Nunavut, 90% of this is from Doug Garson, 90% of our territory's population is Indigenous, and 90% of our elected leadership in our legislative assembly is Indigenous or Inuit. Doesn't that change how we see this issue versus a southern province where Indigenous people are unfortunately a minority and their legislatures do not reflect who they are?
Great question. It is the case that there's work between Indigenous organizations in Nunavut and the government of Nunavut to advance common cause. You see that about 20 years ago with the firearm reference, where the Inuit organization did join with the Nunavut organization to make that joint application. But there's been other instances where the Inuit organizations have not agreed with the government's decisions. And the Cadillac case was a question that dealt with the right to hunt polar bear with a bow and arrow, and there was some conditions that were created by the Nunavut Wildlife Management Board that said, you know, this Inuk could go out and hunt in this way using traditional methods. And the minister overturned that, saying that was contrary to public safety. And the Inuit organization said, no, we disagree with you. And so even in a case where 90% of the people are Indigenous and there's an Indigenous government there by and large, there can be disagreements between the government and the organizations. And so we have to be aware of this idea that disagreement is always a part of the law, and there's different interests that these organizations will have from the government of Nunavut. Now, in particular terms, I'm not sure how the bill would be implemented, because you could see a whole of Nunavut territorial approach to Bill C-92, which would allow for an Indigenous governing body. Maybe it's the legislature, who knows, that would be the repository of the right to exercise these inherent rights under this legislation. But on the other hand, it could be that there are the community groups that would step forward and say, we are the governing body within a particular part of the territory, and they would perhaps disagree with the broader approach that the Nunavut government might take. And so I'm not up to date on the current politics there around this within the territory, but to answer in principle, it does make a difference that there's 90% of the people in the territory who are Inuit, but it doesn't necessarily mean that everyone always agrees with what the government might put forward. And so you could have a lot of innovation occurring throughout the territory, just as you would see within the provinces as different groups step up and want to do these things in a little bit of a different way from one another.
If I may jump in, Nastania, on that question, it's a great question. Another aspect, and I'll circle back to one of the questions that that NTI, ITK, and the ᓄnaᖃᖅḵ government as interveners.
Exactly, that was going to be my next question. So
posed to the Supreme Court of Canada. As a funny or interesting parenthesis, they intervene together, so as in a joint voice. And one of the argument they brought to the Supreme Court was that they said, "Hey, Supreme Court, we know that it's not necessary. It's a little bit outside of the question to confirm that there's such thing as a generic inherent right to self-determination on child and family services, but you need to decide that question." And the reason why it was important, especially for that in the context of Nunavut, is that there is the interest and the difference of a right that is inherent and constitutionally protected versus a right that is defined or affirmed through a law of parliament or of the legislatures. Acts can be repealed. They can be amended. Let's just suppose that in a few years' time, there's another election and another government with different views on self-determination, on child and family services, and on relationship between the Crown and Indigenous peoples come into power and decides to repeal the law or modify it. So, and anything could happen, and it could change the way the act is implemented. Whereas with respect to the people and the Inuit in Nunavut, I agree that it's quite hypothetical how the act as drafted could apply in a particular, given the particular composition of the politics and of the demographics of the territory. That being said, it's a different story altogether if we have a court recognizing an inherent right as first a human right, and secondly as a right that's constitutionally protected under Section 35, in which case incompatible legislation can be struck down. And if legislation cannot guarantee that the right will be protected, there can be challenges, there can be remedies. So this is a part of the decision that let down the expectations of some of the Inuit interveners. But so, and it's an example of where there's still challenge or a little work to be done to make sure that we get to that constitutional guarantee.
So along with this, you started touching up on this. One of the questions in the chat is part of the challenge or obstacle that the governments, any of the levels, do not have proper education or knowledge of Indigenous legal traditions? Is it a lack of awareness or an unwillingness to learn, recognize Indigenous legal traditions? And I'm okay if either of the parties. I'll give John the first opportunity to chat, and then I'll pass it on to Carolyn.
So I could say it could be both, right? It could be a lack of education. It could be unwillingness. The point to make would further the conversation is to understand that legislatures and courts aren't always the source of law. That is, if we're looking to deal with child and family services from an Indigenous legal perspective, the unit of carriage of those principles and processes might be the family, or it might be the more local community. And so in that case, it's not just that the legislature might be unwilling to implement or they don't understand Indigenous legal traditions. It's the very perspective that's formed through a positivistic view of the world that sees the legislature as the be-all and end-all for the creation of obligations and the enforcement of those obligations as part of the challenge here. The decision itself does focus on the positivistic dimension of the law. Parliament here can act to facilitate the child and family services, braiding three things: braiding Indigenous normativity, like Indigenous people's own laws, alongside some national standards that gets joined with the United Nations Declaration on the Rights of Indigenous Peoples that put these things together. And so far, often what we've done is just focus on the domestic legislative initiatives, what might flow from a particular body that's democratically elected. And this decision is saying that these laws arise from sources beyond just that body. At the end of the day, the reference does say the federal government does have the authority to uphold this act. So as Caroline's saying, it doesn't rule on the right to self-government as an inherent right. But the act itself and the decision itself says that the right to be able to, so the ability to make this act effective won't just be a legislative issue. It will also have to incorporate the international dimension. It will also have to incorporate the Indigenous dimension. That normativity on those two fronts is really, really key. And perhaps that's what gets missed when we think about, oh, this legislature is unwilling or this legislature doesn't understand. Part of the problem is it's just focusing on the legislature, and we need to step back and say there's other normativities that now have to be taken into account in ensuring that our families and our children as Indigenous peoples are protected and strong, which I'm now repeating myself again, which is those international dimensions, as well as those local dimensions, again, which could be family, could be more community oriented.
Carolyn, is there anything that you wanted to briefly add to what John just said?
On the person in the audience asked, is it unwillingness or lack of education? I want to address the lack of education. Even when a legislature is in good faith sometimes it's not just a matter of education, it's also a matter of humility. Humility to recognize that, as John, you mentioned earlier on, there's not like one Indigenous culture in Canada. There are many cultures, there are many worldviews that need to be acknowledged, that are all valid and their own sources of norms, laws, and practices. So there's also it's not just whether it's unwillingness or lack of education, but also, are we dealing with a provincial or federal government that has enough humility to acknowledge that it cannot possibly be educated and have all the answers itself, and has the courage to bring into the conversation and give space to the groups and the communities who want to wish to regulate themselves and their people.
I agree. And it goes back to what you were saying, Carolyn, on the issue of legal certainty. It doesn't resolve issue of self-determination, but ensures that there will not be a dispute between jurisdictions. So I think that's a very good way of structuring our mindset. You touched up on this a little bit, Carolyn, and I'm just going to ask again to make sure that there's an actual question with it. How did the court deal with the arguments made by the joint intervention by NTI, ITK, and the ᓄnaᖃᖅ government?
Well, there was a lot of materials brought by those three interveners and by the sum of all the interveners before the court. But there are 2 points that to me are more important in the intervention, the joint intervention of NTI, ITK, and the ᓄnaᖃᖅ government. First, there was the issue, as I touched on before, of acknowledging that there's that inherent right to self-determination as protected by Section 35 and viewed as a generic human right rather than through the Vanderpeet lens. So unfortunately, the court stopped short of addressing that issue. I won't repeat my earlier comments. The other point that was important to the Inuit interveners was to confirm the validity of sections 21 and 22 of the Act, which were struck down by the Court of Appeal of Quebec in the reference, when it heard the reference to the Inuit interveners, though the whole act has to be seen, had to be interpreted or contemplated as a whole, and the whole scheme was to be confirmed as constitutionally valid. In other words, the Inuit interveners said to the court, you can't just set those provisions aside. They're important and they need to be they need to be part of the act if the act, as you said, Nastania, can be implemented and can be put into motion. So on that part, the Supreme Court of Canada essentially granted the point brought by the three Inuit interveners.
Very good point. I'm going to move over to John. So I'm going to answer a question while asking it as well in one of the questions. So the question that we're going to ask is, John, what doors will this case legislation open for Indigenous communities to revitalize child and family services? Will this decision impact Inuit Nunavut differently than other Indigenous communities in Canada?
So one of the things I've seen over the past few years is Indigenous communities working with one another at a family level and a sort of clan and community level to identify what their principles are in relationship to children. So for instance, the Anishinaabe people talk about our 7 grandmother and grandfather principles. And so in law, they've drafted legislation and regulations and created child and family services bodies that function through love, respect, honesty, humility, courage. I'm forgetting a couple of here, but the point is to see that law has an ethical dimension and is about trying to see how love can be more fully implemented, and think through what the stories are within the communities that facilitate love. How are we living with one another in ways that might not be humble, as Carolyn was saying a moment ago? Where are we being untruthful or maybe not courageous? And so, I've seen this happening on the West Coast, say with the Cowichan tribes and the law that they've recently passed to implement child and family services. They use their own teachings, they use their own legal tradition to identify how to go forward. I'm mentioning this with the Anishinaabe people, say with the Peguis First Nation in Manitoba are doing that as well. And part of this work is to change our understanding of where law happens. Law doesn't just happen with lawyers, and it's not just something that judges and legislators do. Law is implemented in our families. Law is enforced by the body that chooses to represent those families, and that those families choose to have represent them, that is in line with those standards that are identified within the legislation. So what I'm saying here is the answer to your question, as it's being unfolded on the ground in many different parts of the country, is to return to an understanding of law that's not hierarchical, that's not just top down, but tries to see from the bottom up and across ways that people can support one another. And that has significant implications for how we often think about bureaucracies that have all sorts of chains of command attached to them. I'm not going to say that those things aren't going to be present. There might be some kind of hierarchy in a First Nations Inuit Métis implementation of law, but the other dimensions that have often been neglected are what I'm seeing come out more fully as communities are innovating around the legislation.
This ties in well with a question that's asked in our chat is by Christiane Brunel. Will Indigenous people be required to prove their relationship with children to be allowed to obtain and use the services? John.
According to this act, no. The federal government has set out the process to recognize the power of Indigenous peoples to do this. Now, the question of who their governing body is, that can be open to challenge, and the Supreme Court of Canada recognized that there could be a future case if there's a dispute about the proper holder of that right. But no, you don't have to prove that we have this right that was inherent to our people prior to the arrival of Europeans. It's assumed to be there, and there's now this process that's present. And if an Indigenous governing body undertakes the mechanisms that are in the legislation, then that step is you don't have to go through it. You don't have to negotiate it. It's just assumed to be existing.
And before we continue on, there's some really good questions that I'd like to just get answered that are in the chat. Carolyn, what do you think? What do you both make of the Supreme Court of Canada's reluctance to endorse a generic inherent right to self-government? Is this decision tied to the Federal Act? Is another case needed before settler law recognizes Indigenous rights to self-government more broadly? Carolyn, we'll move to you.
It's an excellent question. As I said, we have to take a step back and acknowledge how this case came before court. It's a request by the provincial government of Quebec, first with its Court of Appeal, and then it moved up to the Supreme Court of Canada to give an opinion on the validity of the law. So it's not a case that's decided based on facts. And typically courts will want to have facts to exemplify, to make sure that they don't decide anything in the abstract. And because appeal court decisions they have normative force, they are part of the law. So we want law not to be just in the abstract mind of a few justices in their gowns. We want law to be tied with the experience and the lives of people who live in this country. So it was sort of expected, and it's not unusual for the court to step short of deciding this issue because it was not part of the question, like the opinion that the Quebec government was seeking from this Court of Appeal at the first place. It was not part of the questions that were part of the appeal by the Attorney General of Quebec, nor of the appeal by the Attorney General of Canada. And I can understand that the justices were uncomfortable laying down new principles without a factual background, so a firm base, if you will, to set those new principles. So that's why, in my opinion, we'll have to wait until the good facts and an actual case comes before the court, the Supreme Court. So it's not necessarily a reluctance based on the fact that they don't believe that such a right exists. As I mentioned before, on the contrary, I think there are very powerful hints in the decision that point to a shift away from the strict Van der Peet approach and courts embracing the idea of generic rights and a human rights approach, if you will, to Aboriginal rights. So it's not yet, but it's not a no. Definitely not a no.
Definitely maybe, in other words. John, is there anything that you wanted to add to that question?
I don't think either that it's a hesitancy on the part of the court. It is with regard to the narrowness of the question. I saw differences that the court was entertaining in the hearing as different judges asked different questions about, say, the Van der Peet test in the ᓄnaᖃᖅობაში case, which said that the right to governance would have to be inherent to a distinctive culture prior to the arrival of Europeans. And you could see that there were different arguments being entertained there. But as Carolyn said, the decision itself is a federalism decision, basically. Doesn't say much about the inherent right to self-government, other than allowing the federal government to act as if the inherent right to self-government exists within Section 35 and commit itself to acting as if the inherent right to self-government exists in Section 35. And in that regard, the court said this legislation has an educative function. And so the fact that perhaps we'll be learning more about self-governance as it's implemented through these federal and provincial territorial means, that will, with its sort of experience that we accumulate with it, with that educative function, perhaps give rise to a fact situation that Carolyn's talking about somewhere down the road where we can test, is this also a right that's rooted in Section 35(1) of the Constitution that's beyond the federalism criteria.
Very good point. So this next question, I think, is going to be very helpful for next steps for individuals to think about. It's how can Indigenous communities or Inuit communities consider their legal traditions, systems, and sources of law when imagining new ways to provide and govern child and family services in their communities?
So what I've been seeing is that communities are coming together to talk about what their laws are in relationship to child and family services. And this is people sharing tea and having dinner together and convening a process that might go on for 2-3 years, where they sit month to month to month and they share stories. And in those stories, maybe 40 to 120 stories, you see, what are the facts in these stories? What are the issues in these stories that relate to children and families? What are the decisions in these stories? And what are the reasons in these stories? In other words, finding patterns in our stories that function a bit like case law and seeing who are the authoritative decision makers, What are the provisions of protection that are put into place? What are the kinds of due processes that might be there? And of course, revitalizing those laws, not just seeing that what did we do once upon a time. Some of those things that we did might not be applicable today. And so exercising the power of reason and deliberation and persuasion to find the, again, principles and processes that are present. And so that process, if that can happen, that's going to be better than any legislature, better than any court, better than any group of lawyers sitting in a ministry office. We need parents to be talking with other parents about what we're going to do to support and help one another. And if there's challenges, how can we have an intervention that is going to be helpful as opposed to harmful? And that change of imagination around child and family services is probably going to be the most difficult thing to do, because we're so used to hierarchies. We're so used to finding these things as being set in Ottawa or Iqaluit or, you know, in some provincial capital. And this is not just about that. Sure, some overriding support can occur from that point of view, but on the ground, we need people supporting people in a fundamentally different way from the last 100 years. That's more like the way that would occur maybe 150 or 200 years ago, where we just had to deal with it. And we had principles and processes, and sometimes they weren't good. And we need to recognize when they weren't good, and again, not replicate those. But sometimes there's a great wisdom that came from 12,000 years of living in a particular environment and trying to support each other. And those are the points that communities are working on. And if we can see law as something that not lawyers do, but something that communities do, see them as the practitioners, empower them as the agents of the implementation, that will be when this whole thing starts to turn a corner.
Carolyn, especially, so I'm going to ask a question that's from the chat. Especially given the SCC has affirmed the child welfare statute, and in light of the controversial PiyiţշεᓋαουતાЙ et al., doesn't there need to be something more than self-identification as a means to avail oneself of statutes meant specifically for Indigenous people?
Well, in the case of I'll speak specifically to what's contemplated in the act in C-92, which is communities providing their own child and family services. So I think an extension of recognizing the inherent right, ability, and willingness of Indigenous communities to set up their own child and family protection laws and systems. We need to acknowledge the fact that it's those communities, it's those decision makers, and John, you used the word units, be they families or elected community officials and so on. But it will be up to those units, those decision-making units, to determine who is part of the community, who is a beneficiary of those services. So again, we circle back to an issue of education, but also humility from non-Indigenous provincial and federal governments. We need to look to, they need to look to communities and decision-making units within various Indigenous people of Canada to make those their own decision on who's part of the community, who should benefit from those services. So it's not, in other words, it's not shouldn't be up to Parliament or up to a province to decide, well, you're part of that group, or you're Indigenous or you're not Indigenous. It should be it should be acknowledged and accepted that it's the community who decides who's a member or not.
So to try to answer this, because our time is running short now, a question is Nunavut has had legislation for a long time that has recognized custom adoption and gives it full legal standing. Doesn't that incorporate Inuit values? Nunavut has that now.
Yes, I don't think that those kinds of things are going to go away, but what we're talking about is that's the floor that's quite minuscule compared to the work that needs to happen to provide protection, to protect those we love from those we love. And to see that there's due process there, of course, to see that there's dispute resolution dimensions, but to see that families are, well cared for in terms of their shelter and their food and the opportunity for kids to go to school and the appropriate ways. And in other words, what we're talking about is the rebuilding of family units. And yes, the custom adoption is an important dimension to that, but to rebuild families in the light of Indigenous law, international law, and domestic law, puts the best interests of the child at heart, is to say our work is got to be holistic here. And fortunately, the Supreme Court of Canada underlined that holism in its opinion and said the federal government is acting as if that's the way that this will occur with Indigenous participation and voices. And I think that's what territorial governments and provincial governments are also going to have to step up to, is the reformulation of what we even mean by law in this field.
Carolyn, do you think the Supreme Court will deal with the inherent self-government issue in the Dickinson case that is on reserve?
Well, I'm not on top of my head, I'm not familiar with that case, but it's, as I said, it depends on whether it's a question that's identified in the appeal. Like the court has, in order to make a forceful decision that will become a precedent, it needs to be one of the questions that they're asked to answer as part of the appeal, and they need good facts. In law school, when we're just baby lawyers, they teach us, well, bad facts made bad law, and good facts made good law. So we're just having our fingers crossed that the right question will come at the right time with the right facts. So
I'm going to try to ask quite a few, because there's a lot of great questions coming in, so I'm trying my best to answer them all. What can we make of the court's decision of UNDRIP? Has the statute of the Declaration in Canadian law changed?
It's changed at this moment, and another government could come in and say, we don't want UNDRIP anymore. And this decision would allow for another government to say, we're not going to use UNDRIP to influence how we deal with Aboriginal peoples. Because again, this is very much a federalism decision. And it's because the federal government chose to implement UNDRIP that there's obligations flowing from UNDRIP. If another government comes in and says, nope, no, thank you, we're not going to do that, then UNDRIP doesn't seem to have force in this particular framing of the decision.
Great. We only got a couple minutes left, so I'm going to ask the two respective guests to come in and just say a couple of closing remarks. My apologies that we did not get through all of the questions. Very interesting topic. Before we get into that, I just wanted to give a quick shout out to Caden Lauren. He is my youth board of director for the Manitoba Inuit Association. He is very much interested in going into law, and I can tell you with reassurance that this is this kind of stuff that you get to deal with, bud. So I'm very proud of you. And I also wanted to just take a minute to thank Nalini and LexisNexis for this amazing opportunity. I've known Nalini for many years, where I met her on the plane when she was dealing with missing Inuit burials and missing murdered Inuit women. Thank you so much to John and Carolyn for this amazing experience, and it's been wonderful to get to know you guys. I've been very honored and blessed to have this amazing opportunity. John, closing remarks?
I'm just grateful for this opportunity as well, and I think the blending of First Nations law, domestic law, and international law is the message to take from our discussion today.
Carolyn?
Well, again, thank you so much to the Law Society, LexisNexis, for the invitation. Thank you, John, for your sharing your wisdom and knowledge. Thank you, Nastania, for putting us all together and driving the conversation. And thank you for bringing up the beautiful Amauti behind you, which I think was a constant reminder during the talk today of the issues that are at stake and the vision of the Indigenous vision and worldview on child and family relations. So I kept my eye on it, and it was I found it very useful. So thank you, thanks a lot for today.
Thank you so much. Nalini, closing remarks, please.
Oh, I just want to say, like, many thanks, Nakome. Merci à tous. Hopefully we are able to find a way to come together again, perhaps in person in Iqaluit. That would be tremendous. So merci à tous, Nakome. Thanks, everyone. Many thanks.
And without that, this concludes our webinar. Thank you again for everybody for joining, and have yourself a wonderful day, guys.